I spoke with a prospective client today, and there's some marital discord, but we're speaking about estate planning. And this particular person was concerned that her spouse inherited a piece of property out of state and placed that property in trust for the benefit of the children. So it wasn't half bad. Sort of bad, maybe not bad. Good for him. From the legal standpoint, if you receive an asset, any amount of money or property, and you receive it as a result of an inheritance, it will always remain separate property, not marital property, unless you take actions to commingle it. So what this individual did was safeguarded the inheritance that he received so that it would not become marital property. Now, flash forward to my conversation today with this prospective client. She was upset and now wants to protect assets that she has from before the marriage that have remained in her name. So I don't know the full picture about whether or not, the world of the domestic relation law impacts that. So I didn't fully get all of the facts, so I don't know if they used marital funds to pay mortgages and bills and things at that house, right? That I don't know yet. However, if there was separate property, it always remained in this person's name. Marital funds were not used. You could fund a trust with that property, and it could bypass the spouse. These things are possible. If you think there's marital discord, you have separate property, keep it out of your name. No, keep it in your name or put it into a trust, but don't put it into joint names. I'm representing an older person above the age of 70 that's getting a divorce. Now, I have a number of elderly clients in the field of guardianship or estate planning, contesting some aspect of surrogates court. But in this particular case, I'm representing an individual that does not want to be divorced. Doesn't want to be divorced, does not want to sell the property that's owned with the partner, doesn't want to move. So we have this friction, because when you own a property inside of a marriage, well, what can be done? A can buy out B, or B can buy out A, or A and B together can sell to a third party. But what happens when one person wants to sell? Well, ultimately, and this can happen for a young couple, it can happen for an old couple, it can happen for people with adolescent teenagers. You frequently get one spouse that wants the house sold and the other spouse would like to keep it and stay in there. There has to be a recognition that when a marriage ends, the circumstances and the factual situation that existed while you were together can no longer exist. And if you have any value home, $200,000 home, I don't even know that they exist in New York anymore, but 100,000 would conceivably belong to partner A and 100,000 to partner B, subject to taxes and payment and realtor. But even if you have $1 million home, subject to all of those expenses, well, how do you get out? You're close to $500,000. Possibly the only way to do it is to sell to a third party. But my client and my mission is to not sell the property, because that's what my client wants. Or, in the alternative, buy out the other side. And that's some tact and negotiation and prayer. Well, prayer always helps everyone. Even if you just pray to your higher power. I provided some information to a colleague of mine today. This particular colleague is involved in a divorce, and he represents either the husband or the wife, and the opposing side is either the husband or wife. And the issue that's presented to me and why I was involved is one of the intersection of divorce and estate planning. The opposing party is now is extremely ill and may be on, the deathbed. So the idea would be, what could or should happen with that divorce while it's pending, and while this other person has this significant illness and near catastrophic event. So should we withdraw the case? Should we abate the case if necessary by the passing? Can there be a discontinuance of the action? So that was what the conversation was about, and the concerns that it raises ethically, morally, and then financially and legally. My attorney colleague's client would best be served if the divorce did not go through, if the opposing party passed away. Now, in my conversation, I said, let's hope for a full recovery where we don't even have to worry about this. If that would be the case, then my friend's client would get the benefit of the bargain that hasn't been finalized, but say it's going to be 50-50 or distribution of assets in the appropriate equitable distribution format, pursuant to the laws, right? Dividing assets equitably. Pensions, retirement accounts, piece of property, financial institution accounts, stocks and bonds and brokerage accounts. So should the other side recover and live a long and fruitful life, well then the divorce should go through, and then each side would get the benefit of the stipulation or stipulated agreement. However, there would be no reason, and at least the divorce matter should be held a little bit in abeyance until we ascertain, our side of the equation ascertains the health and the physical condition of the other side. Because why only get the stipulated amount, where if the person really is in this significant health crisis, deteriorated condition, this person would, if the one person passed away, the other one would be the surviving spouse, entitled to the full 100% of whatever asset remains open or in existence. So this is the type of conversation I had today. Let you inside. And if you have any questions about this, please reach out. FrankBrunoLaw.com.